one of the concerns that I see a lot of people have when they're thinking about planning for, family who gets one of their stuff is, how long it's actually going to take for those family members to receive whatever was left to them. A lot of times they are under the impression that, hey, I have a will, I'm leaving my house, to these people. When I pass away, they're just going to be able to take the will and get the house. And unfortunately, that's just not the case. So a will, contrary to what I think is a lot of people's thought out there, doesn't avoid probate, which means that if all you have is a will and you say, hey, I want my, and typically I see this with real estate or with a house or something, you say, hey, I want my kids to get my house when I pass away. They can't just go to court or go to the property appraiser or sign a deed and put the property into their name after you pass away. They're actually going to have to go to probate, which is going to take, again, depending on the county and the state where you live, typically what I see is between probably anywhere from 15 months to maybe to a year and a half, 2 years, really depends. And so they don't get it right away, and that can create a lot of problems, especially if maybe there's not enough money in the estate to keep paying the mortgage and they need to sell it, but they can't sell it for several months, or maybe there's a tax exemption on the house and they don't qualify to get that tax exemption until it's in their name. So that's going to take a little while. So for real estate, that's where I see a big problem if all there is a will. Now, if you're trying to avoid that and make it a little bit quicker, there's a couple options. You could put the children on the deed, which again creates some problems because now possibly if they have debts, they get sued and someone comes after them, they could potentially come after that house. Or you leave the house outright to them and they're married. Now that house becomes subject to divorce. So half the house could potentially go to, your ex-son-in-law or daughter-in-law. So there's some problems there. So typically we might say put the property into a trust. So now that the house is owned by the trust, which means that when you pass away, whoever you've left in charge could basically in charge of that trust, who basically that same day that you pass away could could transfer the property out of the trust if they wanted to in their name. They could sell it, and it happens right away, making it very simple, very easy for them. So that's probably the easiest way. Same when we talk about bank accounts. If you don't have any beneficiaries on that account, the kids are going to have to go through probate, which again takes that 15 months to maybe up to 2 years, which could cause some problems. If you leave it to them outright, if you put the kids as beneficiaries, then again, now that money becomes subject to divorce if your kids were to get divorced. So we would probably recommend that you put the money, list the trust as a beneficiary on those accounts, so that then the kids or whoever you leave as in charge of that, they have immediate access to it, but that money goes in trust for them, so that if they were to get divorced, that money is not subject to the divorce. So that's one of the things we would probably recommend. So it really depends. If time is of concern, which it is for most people, you probably want to avoid probate, and then you probably want to have the discussion, should you leave the money outright by list or the house outright by putting them on title, or do you maybe do another type of plan such as a trust? The other thing, if you've got minor children, time is very important, because maybe the people that you want to be guardians of the children, maybe they need access to that money and they can't wait 15 months. Or, they've got their own house. They can't be paying a mortgage on your house and they can't sell it because the property hasn't been transferred. So again, timing becomes very important. So it really just depends on how the assets are titled. Are they in your name only? Are it joint tenants? Are there beneficiaries? Or maybe it's in a trust? And all of those things are really going to make a determination as to how long it's going to take before you actually get those assets.